Hello and welcome to Legally Speaking with me, Tarun Nangia. This is our commencement show on the issue of Prevention of Money Laundering Act in the year 2023. And the issue that we are taking up in that is Section 45 of the Prevention of Money Laundering Act. Now, I know a lot of you people are curious, including businessmen and promoters, professionals, on what is the Section 45. We're going to decode that today along with other issues. I have a guest who is an expert in this, Advocate Archit Singh, who deals with a lot of such cases of PMLA and also of FEMA. Welcome, Advocate Archit Singh, to the show.
Thank you for having me, Tarun.
And at the outset, let's hit the ground running. I want to ask you the first question. What is this Section 45 of the Prevention of Money Laundering Act? Could you explain it and decode it for us?
Sure. Now, Section 45, just like any other act, has provisions for bail. So now we have to understand, Prevention of Money Laundering Act is an act which deals with arrests of persons as well. Naturally, when there is arrest, provisions for bail have to come into play. Section 45 of Prevention of Money Laundering Act imposes some additional conditions from that of the general law of the bail. So this is what we commonly call is as twin conditions. Now, what the twin condition states is that whenever a public prosecutor opposes bail, the person, whenever a bail is opposed, the court has to be satisfied that the person is not guilty of the offense of money laundering. Now, today, unfortunately, this provision is kind of an overarching provision which has forgotten its original application and the rational basis on the basis of which Section 45 was actually introduced.
Okay. Now we'll take this a bit ahead. And well, we hear a lot of terms when we speak of Section 45, the issue of predicate offense and the issue of twin conditions. Could we go that into a bit? What is a predicate offense? What are these twin conditions in specific? Could you share with the viewers?
Sure. Now, Tarun, there's a long-standing history behind the way the Prevention of Money Laundering Act came into play in India or was enacted in India. Now, a predicate offense, as you asked, is an offense which is an underlying offense on the basis of which some proceeds of crime are generated. So it's possible I am dealing in drugs. Some proceeds of crime are generated because I've naturally sold drugs. I've obtained money. Now this money is proceeds of crime because dealing in drugs is a crime. So this is what a predicate offense is. The PMLA has a schedule. The schedule specifies what are the offenses over which a PMLA investigation can be ensued by the Enforcement Directorate. Any offense that is not specified in the schedule cannot be dealt with by the Enforcement Directorate. Now, let me tell you the predicate offense, the link between predicate offense and the twin conditions. There is a very delicate link between the two, and this goes back historically. So if you see, when the PMLA was enacted, the main purposes was that we had international commitments to deal with terrorism, that is terror financing, and narcotics trade, which is one of the biggest sources of terror financing. So if you actually look at the original schedule that was enacted back in the day, there were only 2 paragraphs in Schedule A. And Schedule A is what the Section 45 is applicable upon, correct? There are only 2 kinds of offenses. First, waging war against the state. And second is NDPS Act. Now, naturally, as I gave you the backdrop, when we have international commitments to curb certain offenses which are affecting the society at large, there was certain differential treatment within the bail provisions that was also given to this. And it is not something that is out of the blue, Tarun, that, because it's money laundering, that is why twin conditions have been applicable on over here. Historically, POTA, which deals with terrorism, TADA, which dealt with terrorism, UAPA, which is currently the law, which also deals with terrorism, and NDPS Act, which deals with narcotic trade. All of them have provisions which deal with money laundering. All of them have provisions which had twin conditions. So there was a natural nexus between Section 45 being added in the PMLA originally. Now, what has happened is that over time, this PMLA has been amended, right? But what has been forgotten is that PMLA was always intended to give differential treatment based on the predicate offense. Let me give you an example. If you read when the PMLA was enforced in 2005, at that point of time, another condition was imposed, which was not in the original bill, which is a 3-year period that is given in Schedule A. The offense has to be more than 3 years, punishable with 3 years. Now, one would say only 2-3 offenses are there. Why is this even being brought in Schedule A? But if you go into the NDPS Act now, any offense that is punishable over 3 years is actually dealing with commercial quantities or intermediate quantities, which means narcotic trade. There are offenses there which are punishable 1 year, which is less than 3 years now, which deals with personal quantity or something that is being in a private consumption it is for. So there is a natural nexus, the way it is being dealt with entirely, a differential treatment is being given. Second, if you look at Section 4, which provides for punishment, a differential treatment is again given for offenses under Schedule A, Paragraph 2. Until date, Schedule A, Paragraph 2 deals only with the NDPS Act, which means from 7 years, the threshold of maximum punishment increases to 10 years.
Okay. Now, having explained all of this, the only curiosity that we have to know from you is about the amendments to Section 45 that have happened over the years, and after the amendments, what are the results? Because people would want to know.
Correct.
What difference does those amendments make? Could you share that with the viewers?
Sure. So, Tarun, the first amendment that came about to the schedules. So these are amendments that are actually taking place, Section 45 and the schedule together. Now, the first amendment that took place was in 2009. This is an innocuous amendment. Nothing much is added. Counterfeit products are added in the IPC. More offenses are added in the NDPS Act. Explosive Substances Act is added. And UAPA. And let me tell you, terrorism was made an offense in UAPA in 2004. Twin conditions were added in 2008. So naturally in 2009, this is added to the schedule as well. And the twin conditions apply to all of these offenses, which again you see are very heinous crimes. They are not normal offenses. They are again dealing with the original purpose of Section 45. The problem comes in the amendment that took place in 2012. This was passed in 2012. It's known as the 2013 amendment.
13 amendment.
Correct.
Okay.
Wherein the entire Schedule B, now we've talked extensively about Schedule A and the limited offenses. Schedule B was larger. Schedule B had much more offenses. Right? All of these offenses were, one, increased, and secondly, shifted to Schedule A. So Schedule B was made entirely redundant. Okay. Now, when you read this with Section 45, unfortunately, this gave rise to a discrepancy. The discrepancy was, one, as we discussed, the original purpose is lost. Every offense is now Schedule A, so every offense, the twin conditions are applicable. Second, there are a lot of offenses in Schedule B, or now as they're in Schedule A, that are actually bailable offenses. So for an offense wherein predicate offense, I can get bail. In PMLA, I have to, on the contrary, go through the rigors of the twin conditions. That is, I must prove I am not guilty. Thereafter, there was one more amendment, which was in 2015, but this was a very small amendment. Customs Act was added in Schedule B, and finally Schedule B had some purpose to play with, and 30 crore limit was increased to 1 crore limit. So 30 crore limit was applicable on Schedule B, that any offense. So even in Schedule B, it was not any offense of any nature. Offense had to be qualified, and there was a qualification of a monetary limit. This was increased, and this is what was ultimately challenged before the court as we know as the famous Nikesh Tarachan judgment.
Very interestingly, a lot of people would want to know about the Nikesh Tarachan judgment, famously authored by Justice Rohinton Nariman. Could you explain the judgment for the viewers? This is something a lot of people want to know, because I think it's been the most discussed judgment in the past 5 years.
Yes. So Nikesh Tarachan Shah was the judgment in which the Honorable Supreme Court, and it was authored by Justice Rohinton Nariman, who was one of the brightest judicial minds we've had in the past many years. Now, what transpired in the judgment was, after hearing arguments and after analyzing the amendments, you see, even over here, interestingly, the court also points out the entire way the evolution of Section 45 takes place. And it comments, there is a problem in the 2012 and 13 amendment. Okay. Now, the correlation was that now the court struck it down under Article 12 read with Article 14 read with Article 21. My apologies. Now, the court observed that there was, First of all, as we had discussed, on the same ground, the court said there is no reasonable classification for implementing the twin conditions anymore regarding Schedule A because everything is redundant. Correct. And secondly, the court also recognized that there was a difference in the way anticipatory bail and regular bail were treated. If I obtain an anticipatory bail in the beginning of the investigation, twin conditions are not applicable on me. Whereas if a regular bail is there, the twin conditions become applicable. So that is how the Nikesh Tarachan judgment came into being. And eventually in 2018, this discrepancies that were brought into play, the relationship between predicate offense and section 45 was removed by way of an amendment in 2018, which was one of the biggest things that were considered.
That will be my next question, that as you said, in 2018, the amendment removed the dependence of section 45 from the scheduled offense.
Yes.
And connected it to the commission offense of money laundering.
Precisely.
Delve into that issue a bit. What does it mean? What implication does it have?
So, Tarun, firstly, once the dependence on predicate offense goes, it simply means that any arrest that takes place today has to be an arrest under the Prevention of Money Laundering Act for the offense of money laundering. Now, this has given a rise to certain lacunas. See, even if we otherwise look at the way the arrest and the bail provisions work in Prevention of Money Laundering Act. Now, the arrest under the Prevention of Money Laundering Act takes place under Section 19. Section 19 signifies that while the arrest has to take place, the arresting officer has to be in possession of reasons to believe as to my guilt. So a prima facie opinion of guilt has to be formed on the basis of material in the possession of the person who is arresting me to even arrest me. Now, this is a funny position that is happening because if you look at it today, maximum number of arrests that actually take place is because of non-cooperation. Correct.
Okay.
It is not because of guilt. It is that, the person is not cooperating, the person is not answering truthfully. These are what is given as grounds of arrest while the arrest takes place. Now, this is where the biggest problem comes place. As per my understanding of PMLA, this cannot happen. Because if you read section 63 of the PMLA, that is actually where the remedy for the ED lies for if any person gives false information or failure to give information, then that is a separate proceeding. One that has to take place before the adjudicating authority. Two, the ED even otherwise requires a prior sanction for the government to even proceed against this under this section. So today when arrests take place on the grounds of non-cooperation, it is a funny position because a pure reading of section 19 shows that this is not possible. Now, if you correlate section 19 with section 45, section 45, the twin condition, that is the second condition that is, and let me read it out for you, Tarun. I think it will be for the benefit of the viewers. Where public prosecutor opposes the application, the court is satisfied that there are reasonable grounds for believing that he is not guilty of such offense and he is likely not to commit. Now, let's forget the second part.
Okay.
So there, first of all, one of the biggest problems that is coming today is that there is a reasonable belief that I have to go to court and I have to prove I'm not guilty at the threshold of investigation where I have no evidence in my possession. Whereas the law reads slightly to the contrary. It says where the public prosecutor opposes. Read this with section 19. It means there is already reasons to believe a guilt that the agency has. The public prosecutor has to present those reasons to believe with evidences because this is reasons to believe in writing. And those evidences, otherwise, how can a court reach a conclusion of guilt? It is an impossible situation for a court to reach conclusion as to guilt without appraising the evidence. Now, this is where a second problem comes in. The general law of bail says that a bail proceedings are supposed to be quick proceedings. They're about personal liberty. They're not a mini trial. But the way section 45 formulates the entire proceedings, it actually makes it a mini trial because the court has to appraise evidence. And Tarun, here's where the second lacuna comes into play. Can a court appraise evidence without actually going into the admissibility of that evidence? And the court only goes into the admissibility of the evidence when a report is filed. Now, interestingly, if you read, there's a proviso to twin conditions. There are two provisos. First talks about some exceptions. Second proviso states that further special court shall not take cognizance of offence punishable under section 4 except upon a complaint made in writing by the director. Now, interestingly, why will there be a provision for which takes into consideration cognizance under a provision for bail? Now, this is a very funny situation because naturally it means that somewhere it is talking about appraisal of evidence which only takes place during cognizance. And that is how you determine guilt. So this provision, the way it's couched, has many lacunas, and which I think will be a subject matter of a lot of proceedings in the future as well.
Now I come to the most important question, which is a result of what you just shared with the viewers. What are the problems of business and promoters who face these investigations? If we take into account the resurrected section 45 of the Prevention of Money Laundering Act, if you could just list those problems, possible solutions. Of course, we have little time for, because I think you would have lot to talk when you speak of solutions, but whatever is possible, if you could share with the viewers.
So I think, Tarun, one of the biggest problems is when an agency has been empowered with such draconian powers. And see, people, the first question, naturally, be it an Indian, be it a foreign promoter, be in foreign companies, the first question is, can I be arrested? Yes, you can be arrested. What happens thereafter? Do I get bail? When can I be arrested? So one of the biggest fears people have is, what if the agency just doesn't like my answer and they arrest me? Now suddenly section 45 comes into play and I'm not going to get bail. If you remember in our last show, we had spoken about this, about the problem regarding supplementary complaints and charge sheets, which means that if I'm arrested and the prosecution moves the first charge sheet or the first prosecution complaint, as they call for ED, within the time period, I will be in jail. Then they can keep moving supplementary charge sheets. So there is no end, because to prove not guilty within these specified parameters is an oddball exercise without there being a trial. So this is something that really scares a lot of people, that, okay, what if they don't like my answer? Second, one of the solutions around this is the way you answer to the agency also matters. I believe a lot of times people are unable to grasp, and you have to gather from the entire thing, what is an investigator looking at? Because sometimes what happens, Tarun, it's actually not that you are giving the wrong answer or the agency is just malicious. Sometimes as it happens is the agency is seeking X, whereas I, not able to understand what is to be provided, provide Y. So this gap starts happening between an investigator and a person who's being investigated, wherein the information becomes the biggest point of contention. This is where the agency will come and say, look, the person's not cooperating. I'm asking for something, they're not giving me the right information, wherein it is within their possession. And I have no problem giving that information. The only problem is I have been unable to understand what is this information that they're seeking. What is the purpose behind this information that they're seeking? Because every agency has a goal in mind, right? Where is this prosecution heading? If you're not able to understand where the prosecution is heading with its case, you will falter.
Okay. You touched a very, very interesting point, that the client or the one who's being prosecuted should be assisted by a lawyer able enough, who should be able to analyze for himself where the prosecution is going.
Yes.
So that he can assist and come to help himself. Is that what you're saying?
Correct, because as long as you're showing compliance, even a court will not admit that to be a ground for arrest, right? If I am able to show compliance.
You're not advised rightly and you go wrong there, and that may lead to arrest. I think it's a very, very good note to end this show, because we have learned on section 45 of PMLA, and also in the last answer was very enlightening. I think the key takeaway was also, in addition to all the points Archit made, was very interestingly, he said that if you can't even decipher where the prosecution is going and you're not able to provide what they want, you may end up being arrested because you'll basically not cooperating. It's a very interesting point. But that's it for now, and looking forward to see you, Advocate Archit Singh, on our upcoming series on the review petition of PMLA. All very important. I think 3 or 5 judge benches, the Supreme Court is going to do that hearing. We'll get to speak forward to that. And thank you so much for sharing all this, and thank you for joining us on Legally Speaking special series commencement show on the PMLA. Thank you so very much.